Hello, everybody, and welcome to the KopCam channel, the KopCam live stream. Welcome in. Welcome to the live stream. Okay, we're showing up live on YouTube right about now. Look at me. I'm looking scruffy. Oh, wait. Yep, I'm looking scruffy as all hell. But I got a good black background going here, good chroma key screen. So it's all good now. Back, haven't done a live stream in a while. Got a pretty interesting subject today with the live stream. I have a court date today in this case that I picked up in Broward County. And now, apparently there's been a document filed in the record by the prosecutor. Writes Crispy, what's up? Welcome in. Listen, I was just describing it. Stick around. This is huge. This is huge. So let me start over real quick. Okay, I'm gonna go from the beginning now. And everybody who's coming in chat, Finn, do me a favor. For everyone else who comes into chat, I'm going to ask you to sort of like I don't really give anyone necessarily wrenches, but I mean sort of moderate for me on this for the next few minutes. Let everybody know that I'm describing the whole situation. And for those who come in later, see if you can, kind of give them a little backup for me. Okay, Boosted LSS, welcome in. Okay, because I don't want to have to keep. In other words, I'm not going to be paying attention to chat for a few minutes while I describe the whole situation. Okay, so now some of you may remember I picked up a case in Broward County, like now maybe a year ago. That's been delayed over and over and over, and I've already said to the court that they need to dismiss the case on grounds of speedy trial. Anyhow, I got a court date, one of those Zoom court date hearings today, and at 11:45. And by the way, this was the same case where I sued the towing company. I picked up $3,000 in like a couple of weeks. They settled. So this towing company settled out, and I got $3,000 out the deal. But this is a different deal here going on. And this is going to involve some discussion of law. And I got about 20 minutes to do it. 11:45 is the hearing, so I'm probably going to dial in. I'm probably not going to broadcast the hearing. I'll probably keep the stream going though, and just let the judge. I'll probably keep the stream going though, but maybe you won't see me. You'll just say something like, "Please stand by while I do the hearing." So that's pretty much that. But anyhow, some stuff has come up now. Okay, now an event. I got the hearing today, and I look in the docket, and the state has filed. Well, I'll just go ahead and read it to you. Actually, let me do this. Let me bring it up. I'll actually bring it up on the screen here so you can see it. Why? Because we could do that here at the KopCam channel. We can do that kind of thing. Give me just a second here. Yeah, let me do that. Let me bring it up on the screen, and I will. Let me bring it up on the screen real quick, and I'll give you some background also what's going on. So now they filed a notice of discovery, okay, in the case. Let me bring this up here. They filed what's called a notice of discovery in the case, and let me give you some background on this real quick. Let me give some background real quick on this. Let's see if I can show that screen. Okay. Let me go back to me real quick. The case is Brady versus Maryland. That's and there's a Florida Rule 3.220. So I'm going to do the best I can to decipher this with you, because I'm not sure what the whole damn thing means, and I got about 10 minutes to do it here, but I'll be able to do that. We're going to dig into this, and we're going to actually try to figure out what the hell this thing means. And if any of you know, by the way, certainly fill in. And we're also going to see if we can get some intel from you, because I'm going to need to get some intel from you about this. Okay, let's get the docket up here real quick. Okay. Here it says file states, let me bring this, make it a little bigger. Boom. And bigger yet. Okay. File states notice pursuant to rule 3. 3.22 file states notice person to 3.22 subsection 4. So Florida rule 3. And I think the way the Florida rules are designed is that you just type in the number, and if it's 3, it's the rules of criminal procedure. 4, it's something else. 5, 6, 7 is appellate, whatever. So you don't even have to type in know whether it's civil or criminal. You just type in the rule number, and it'll be sort of explanatory. I think where she's talking about subsection 4 is down here, where it says, as soon as practicable after the filing of the charging document, the prosecutor shall disclose, and I'll actually make this a little bigger as well. As soon as practicable after the filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant as to any offense charged, regardless of whether the defendant has incurred reciprocal discovery obligations. Now, what the hell? Tends to negate the guilt of the defendant. Well, let's have a look at that document. Let's have us a look-see at what is going to negate my guilt today. No, that's not what I want. What the hell is that? That's not the one I wanted. File states notice pursuant to rule. These are both the same. They're both duplicates. Oh, yeah, that's a duplicate. What the hell? Wait a second. Oh, here we go. B4. Okay, 3.220 B4. I think that's where we went. Yeah, so it comes now, state of Florida, by and through the undersigned assistant state attorney. Oh, this is Harold F. Oh, wait. Harold F. Pryor is now stated, but her name is Lynette De Los Santos. Oh, you know what? You're not an Esquire. You, Miss De Los Santos, are not an Esquire. Don't say you're an Esquire. That shit's obnoxious. It's fucking Esquire. How about this? You know what? You're not an Esquire. I don't know what the hell that is, but you're not an Esquire. I don't even know what it is. You're not that. Stop that shit. The fucking narcissism, man. We're tired of you people. Comes now the state of Florida by and through the the undersigned assistant state attorney pursuant to rule 3.220B4, Florida Rules of Criminal Procedure, submits the following information which is in the state's possession or control, which may fall within the purview of Brady v. Maryland and or Rule 3.220B subsections, Rule 3.220 Section B, Paragraph 4, or some shit like that. Broward County Sheriff's Office Office Deputy Ruben Alvarez is the subject of a grand jury review wherein a person, apparently redacted, died as a result of police action. Okay, now let's stop right there. Let's just stop right there. Okay, this guy Ruben Alvarez is the guy who charged me. Okay. Let's stop right there. Let's just stop right there. Take a step back. Oh, damn. Stop. Take a step back. Step away from the microphone. Step away from the. What the hell is? What are we doing here? What the hell? I mean, somebody chime in the chat real quick. And tell me what you think about this kind of thing going on here. You see what I'm saying? Because, just a minute, let me fiddle with my screens here for a second. Because, does anybody know? First of all, does anybody know any of this? Anybody got any intel on this Alvarez guy? Anybody know? Does anybody out there in the Florida area know about this particular case? Because I'm looking for it real quick now. We're gonna probably look that up and see if I can get some intel on that just right away here. Just a second. Damn it! Come on, computer. All right, so let's check in with the chat real quick. Lundell, yeah, that's fine. Thunder Rolls, hello, Mark Miller. Okay. So, do you know anybody in the chat? Do y'all understand what's going on here? apparently this Ruben Alvarez, I don't know. I don't know. Shooting? No. Broward County. Jiu-Jitsu fundraiser held for family of BSO deputy killed in April 16th, 2019? Maybe. From Deerfield deputy killed in Deerfield Beach crash. No. Yeah, you know what? He talked about how he was a black belt in jiu-jitsu or some shit, but I don't give a fuck. Fuck him and his jiu-jitsu. I got nut jitsu, man. I got knee to your balls jitsu, man. Give me your fucking jiu-jitsu. Anyway, so Broward, who knows? Subject of a grand jury review wherein a person died as a result of police action. Well, let's talk about that a little bit. Grand juries don't review shit. Okay, the purpose of a grand jury is not to do a review. Okay. Grand juries don't review. What they do is they determine probable cause to indict. That's what a grand jury does. They determine probable cause to indict. I'm checking the time here real quick because I'm going to be saying the same thing to the judge here in about 15 minutes. Grand juries are convened to determine probable cause. Typically, the defense is not allowed to appear before the grand jury. So, when the prosecution goes in front of the grand jury, and it has happened, I did hear about this. I think it was one of those cases in Ohio or something, but it's definitely a case where a cop killed somebody. What did the prosecutor do? The prosecutor went in front of the grand jury and attempted to plead basically justification or necessity. Basically a justification defense is what it's called. Okay. Let's see. Yeah. So it's called a justification defense. Justification and necessity. And a justification or necessity, those are affirmative defenses. Justification defenses are affirmative defenses. Affirmative defenses are pled to the trier of fact. Okay? They're not determined by the grand jury. They are not decided by a prosecutor. Prosecutor does not have discretion to make a decision to prosecute or not based on an affirmative defense, a potential affirmative defense of the defendant. That's not part of their probable cause. A potential affirmative defense of a defendant is not part of their probable cause. So, and they are not there to plead affirmative defenses to a grand jury, but they do. They'll sit there and tell a grand jury that, it's justified. That's not their place. So, and that's a very serious level of corruption for prosecuting attorneys to do that. Think about that for a while. But yeah, it is about as corrupt and filthy as you can possibly get. So let's have a look at this real quick. Anybody here in chat? Real Jingy? Jing, that's a very good question because that's what I'm going to be talking to the judge about today. I might, if I get a chance to, if they'll let me speak freely, which they don't, I will be mentioning that to the judge like, what if that was me? I want to find out the details of that. But the question is that it says it tends to negate the guilt of defendants. So let's go back and read that again. Actually, let's look up Brady v. Maryland. That's what I'm actually looking to do here. Let's look, because I remember hearing Brady versus Maryland and using it in past over this, that, the other thing. I can't remember what it is before I look it up. If I can't remember what it is specifically, but if I look it up, I'm going to think it's going to be exactly what it said there in that rule. That rule actually, I think actually is literally the whole point of is actually the core point from Brady versus Maryland is that if the prosecution is in possession of information that tends to negate the guilt of the defendant, they have to disclose it as soon as possible. Any exculpation. Yes, that's it. Brady versus Maryland always compels the prosecutor to disclose exculpatory evidence. Okay. Yes, Brady versus that's what I remember now. Yes, Brady v. Maryland is if the prosecutor has exculpatory evidence in their possession or knows of it, whatever, it is to be disclosed. They have an obligation. Fail to do so is malicious prosecution. Fail to do so is deliberate malice. And even spoliation. So, and certainly tortious deceit. So, I would like to hear this prosecutor's theory on how this, and actually in keeping with Brady v. Maryland, there's also something else. Prosecutors have a duty to take into account what's called the totality of circumstances. Okay, the totality of circumstances. They need to make their decision to prosecute within the totality of circumstances. They need to examine the totality of circumstances in making their decision to prosecute. But as I said before, affirmative defenses are pled to the trier of fact. This means that a police officer who knows they killed somebody has an official duty to turn themselves in and charge themselves with a crime. That's sort of their last official act at that point. If they know they killed somebody, they have an official duty to, at that point, book themselves into jail for having committed a crime. Because they know they did it. When a police officer knows somebody committed a crime, they have a duty to... Well, when a police officer knows somebody committed a felony... Now, misdemeanors are typically left to the discretion of an officer. Like, you can charge or not charge. But when you have knowledge, direct firsthand knowledge that a person, including you, committed a felony, or you're a police officer, you have an official duty to arrest that person, which means he has an official duty to turn himself in and charge himself with the crime he knows he did. If he has some claim of justification about it, or some kind of necessity or affirmative defense to make, well, he can plead that to the trier of fact like anybody else would. He needs to be telling his story to a jury. You see? So... boosted, yeah. I mean, I get you on that, but I don't... Well, who knows? I don't know. Yeah, exculpatory evidence must be disclosed. So there's your Brady versus Maryland action right there. So, oh man, we got somebody calling. Just a second. This might be an Indian recruiter. Just a moment. Hello?
Okay. Hi, David. My name is Prasad. I'm from Accelerator Innovative. It's a good time.
Yes, it's a great time. What's your name? Prasad?
I'm doing good. How are you doing?
I'm doing well, but what was your name again? Prasad?
Right. My name is Prasad. And if there's a power development opportunity, I'd like to talk to you.
Sure, just a moment. And you're with Accelerated Development Solutions?
Okay.
Are you the implementation partner, or are you the direct vendor, or are you the implementation partner?
This is for my direct client, Broadridge Financial.
Who financial?
Broadridge.
Broadwich. Where's the location?
The client is in Fundraiser. Can be remote.
Okay. I got to be honest with you, man. I've been a Perl programmer for at least 20 years, and it's cool. There's still people using it, but I really don't like working with middlemen. I want to work directly with the client. I have my own corporation. So if you can work a deal, we'll see what we can do. But I'm corp to corp, and I want to go direct with them. So you got to figure out something to do, okay?
Yeah.
Oh, all right.
I'll be in touch with you.
All right. I'm sure you will. Thank you very much. Yeah, so much for Prasad and his Perl developer opportunity. Not too interested in that. No, I mean, I'd love to do it. It's amazing if there's anybody still... by the way, if there's anybody out there still needs a Perl programmer, call me. I love it. It was a fun language. It's, and I met Larry Wall personally. He's a cool guy, but I can't say much more than that. It was a cool language, powerful language, did a good job with it, still use it for some stuff. There's apparently some people still using it, but like so many people, I got hip to Python and just, are able to do a lot of cool shit with Python as a scripting language, and then I'll typically go with C, C++, Java, those languages. But even everything, they can constantly come out with new shit just to keep people like me, make people like me get old. So it's you could still use freaking Algol 68 if you fucking wanted to, man, to program. It doesn't matter. You could do it assembly, just ones and zeros and shit, but thing is that they come out with new languages so that you always have to study new shit and buy new books and this, that, the other thing, and become obsolete, this, that, and the other thing, and the Indian recruiters can go with somebody else and the whole bit. It's all bullshit. So, oh man, Big Nick, how you doing, man? Order 10 of them. Yeah, hell yeah. So, Nick, let me tell you what's going on here in the case. I got a few minutes before the Zoom hearing, man. This is fucking crazy. It was the same judge that you were in trial for. And she said to me during one of the Zoom hearings, she said, Mr. Bagoni, full disclosure, I know that you were in my courtroom during the trial of Mr. Freeman with a camera. She told me straight. So she knows. Now, it turns out the cop who I just got to notice this, you might be able to see it on the screen. Well, I'll put it back up real quick. Just a second here. There we go. File states notice pursuant to Rule 3.2204. Brady versus Maryland. Disclosure of exculpatory evidence must be disclosed. Broward Sheriff's Office Deputy Ruben Alvarez, he's the guy who wrote the ticket, is the subject of the grand jury review wherein a person died as a result of police action. Okay, and the person's name might have been right there. I don't know, but so anybody who's got some intel, anybody who's in this area who's got some intel on this, whoever this person Alvarez killed or whatever, I don't know. See if we can find out. More important, more to the point. Grand juries don't review. As I've said it before, grand juries do not review. They determine probable cause. Typically, a prosecutor is the only party who gets to present their case to the grand jury to determine probable cause. So if a prosecutor pleads justification or tries to inform a grand jury as to justification, whatever, that's just bullshit. So, So I'm going to see about dialing into that Zoom hearing, but I got to figure out a way where I I think I can mute the phone. Yeah, I think I can mute the phone. Yeah, we'll see real quick. Just a second. It's about time for me to start dialing into that Zoom hearing, so you can actually. I can put the Zoom link up. I can put the Zoom link up on the screen. There's certainly nothing wrong with that. Okay, so in other words, and in fact, well, I can't see. Unfortunately, I can't copy the Zoom link because it's in a PDF and my thing doesn't cut and paste. Okay, so the Zoom link is up on the screen. Somebody please do me the favor of taking the time to type that link in if you can, or the Zoom meeting ID if you can see that. I got to fiddle with the phone right now. So 646 876 9923.